Wait, please, Your Lordship. Your Lordship, I beg to mention item number 7. The connecting counsel is out of station.
Complaint made by the respondent, not objected to by petitioner, matter is adjourned. Let's say after 2 weeks.
Highly obliged, Your Lordship.
On daily list, item number 1.
My lord, in this case, in the connected matter,
The matter is coming on the 3rd, my lord.
yes, issue of notice upon the complainant will come on the 3rd.
It's coming on the 3rd, that other matter.
Maybe list that thereafter, my lord.
On pre-made report, we list it on Friday.
Monday, my lord. Next Monday.
On pre-made by parties, list this matter on Tuesday. One is holiday. If you want to come, you can come.
It can be listed along with that other matter also.
No, the matter is on 3rd.
3rd.
Hey, no, that's a different thing.
That's a different thing.
Obliged, Lordship.
Any order that is passed in that case
My lord.
will have a bearing.
It will have a bearing in this one.
Obliged.
Item number 2.
None appears for the parties. List this matter after 1 week.
Item number 3.
So this is the matter, Lordship, where the state respondents were supposed to produce some documents today, Lordship.
May I please, Your Lordship,
This is that teacher matter, Lordship.
the leading counsel in this case, KP Bhattacharjee, due to some personal difficulty, he could not come. So if this matter may be taken after 1 week, Your Lordship.
If I'm not mistaken,
He was supposed to file an affidavit,
so
Lordship.
last file an affidavit or file the produce the record.
Initially, he's praying for affidavit, where he's supposed to serve me a copy. And last week he made a submission that he will produce it in court only, Lordship.
Your Lordship, if that be the case, let this matter may pass over for a day, Your Lordship. Let it come up tomorrow.
This order dated 14/2/2025, Lordship.
If I'm not mistaken, can you produce the record? Don't put his name. Was when this matter came up.
Last week, Lordship.
Yeah, he's here.
I was in court number 2, my lord. Just finished.
You're supposed to produce the records.
Yes, my lord. My lord, this is the relevant one, my lord, that day.
You produce the record in the original, Mr. Chaji.
My lord,
Lordship, let
the
him
earlier,
file,
no, my
let him
lord.
file affidavit, Lordship. Where
My lord,
you
what had
can give me
happened
a
in the
copy,
earlier
Lordship.
occasion, my lord, I had produced the record. The Honorable Court has gone through the record. Then the matter was taken up for hearing, my lord. Now, in the course of the hearing, our stand was that she has already participated in the selection process. She doesn't have a case. So thereafter, my lord, there was a query from this Honorable Court that where is the advertisement, where is the list. So, my lord, that we have produced, my lord. If required, we will file an affidavit.
Let them file an affidavit also.
My lord will kindly see, everything is very clear. The signed, the list of the features.
See, filing of affidavit, bringing on record certain, documents or certain latest development, whatever, it's a separate thing. But producing the record is another different thing altogether.
That was already done, my lord.
The court can produce whatever is there. But they have
That
also
was already done before this honorable court. My friend is misleading this honorable court.
No,
That
Lord,
was
sir.
already done.
No, Lordship. They didn't have the
My lord will
documents in the
kindly
last
see the
occasion,
last.
Lordship.
if that is the
Can you
case,
see
then
the-
My lord,
the-
he
the
has
last
she has
order,
participated in the selection process.
whatever the case may be,
My lord,
if you wish to produce this record by way of affidavit, then do it.
Let them
Okay,
file,
Lord.
Lordship.
Because that would, you see,
because petitioner is blatantly lying before this honorable court, my
Lordship,
lord.
I didn't even have a copy of it also.
My lord, petitioner is well aware. She has participated. I can show him the copy now.
that will be
This is
borne.
blatantly lying before this honorable
Let
court,
him
my
file
lord.
a
She
affidavit
should
and
be
we
booked
will
for
examine
perjury,
it,
my lord.
Lordship.
In fact, on the last occasion, my lord, before the, it was on, my lord, if the matter, when the matter was last taken up, in fact, I had produced it before this honorable court.
That's what I said. Then you said, okay, we'll do it on the next date. So the date was fixed today.
Yes,
The matter was not even taken up, Lordship,
Yes,
because of
because-
that emergency.
but I
Because the
had
paucity of
informed this
time,
honor-
whatever.
Lordship.
my lord.
So you file
I'll
an
file it
affidavit
then,
then.
my lord.
Lordship.
In course of hearing, Mr. K.P. Bhattacharjee, letter J, has submitted that there are certain documents available on record which would indicate the stand of the petitioner to the contrary as far as the process of recruitment or participation in the selection process is concerned. The learned J would submit that he may be allowed to produce such documents by way of an additional affidavit. On premier, the same is allowed. Let the said affidavit be filed with the next date fix with an advance copy to the petitioner to allow her to file a rejoinder if so advice.
One week, man.
1 week.
1 week.
My lord.
This matter on 11th. We, Dr. AM. This is matter 11th. So 11th.
11 years. Deeply obliged.
Item number 4.
Yes,
This is the matter relating to VRS of MEDCL employees. My lord, on the last date I had placed before your lordship the brief outline of the case. Now, my lord, here what has happened is that though the employees have been extended the golden handshake,
okay.
they have been given the VRS, but however the entire benefits have not been released to them.
Okay.
The entire benefits is not released to them, and whatever benefits was released, it was released in 2 installments, 2 or 3 installments, over 3 financial years. However, as on date also, as per your own admission, my lord, if 31st July 2011 is to be taken as a cut-off date, there still remains a sum of 1 crore 81 lakhs and some thousand rupees to be paid to the employees. Now, my lord, in this case, what has happened is, though the
Have you stated the calculation?
yes, my lord, everything is there. Everything is there in the writ petition, my lord. Now the
Your Lordship, if I may interject, Your Lordship, there are private respondents also here who are necessary party. And Your Lordship.
Private respondent? Why?
Yes, Your Lordship. MEDCL, Your Lordship.
well, they already represented, my lord. Mrs. Yangi
Your
is
Lordship, they're
representing.
required to be here for the hearing today, Your Lordship. Cannot be taken up if they're not here.
The government advocate is not appearing for all the...
No, Your Lordship.
The government advocate is appearing for the Department of Industries, Government of Meghalaya.
Okay.
They are not there today.
Who is respondent?
Respondents 5 and 6, Your Lordship.
5 and 6.
Then there is 4 and 5, that is the MEDCL and the MIDC. MEDCL is the subsidiary company and MIDC is the parent company.
But of course, they are a corporation, isn't it?
They are represented by Mrs. T. Yangi, senior advocate. In any event, if they are not here today, my lord can fix a date, my lord, tentative date when this matter can be taken up on board and.
Yes, sir. Okay. So 1, 2, 3, and 4 is they are represented by the government.
Yes, Your Lordship.
Government advocate. And 5 and 6, they are
5 and 6. 5 and 6 by Mrs. Yangi.
Mrs. Yangi as what? In what capacity?
Yes, she is the standing counsel for MIDC, but in this case, she appears for the MEDCL also. She is appearing for both the.
Your Lordship, here the state's role is limited, Your Lordship, because we have extended the scheme to them as a one-time payment, Your Lordship, because they are not state employees also, Your Lordship. So our role in that way is limited, Your Lordship, because whatever scheme has been given to them has been released as a one-time payment on humanitarian ground.
My lord says the council is not there.
You see, whatever the modality and mode of the scheme, implementation of the scheme, would rest on the respondent 5 and 6. Not necessarily on the government would.
My lord, what has happened? What actually happened here was, when this matter was before this matter was placed before my lord's board, when this matter was heard, my lord, 2 queries befell from this court as to whether the company has been fully liquidated, whether the winding up process of the company is complete, and if there are any dues. My lord, to that effect, the state has filed an affidavit, my lord. Now the affidavit makes it very clear that they are not denying that there are no dues. My lord, the dues have been placed, the proposal for sanction has been placed before the government, and time and again the government has deferred the sanction on one ground or the other. But at no point of time had they said that they are not that they are not liable for payment. It is there in their own affidavit.
Why don't you work it out? You should have tried to negotiate with the government. And if it's only a question of disbursement.
My lord, it
would depend on the
My lord, there are two aspects of the matter. Here, the cutoff date for VRS was unilaterally decided by the government as 31st of July 2011. However, the last installment which was paid to us was on 2014. My lord, our prayer before my lords is that, my lord, unless the entire package in the VRS is paid to the concerned employee, my lord, the dual relationship between an employer and an employee continues. My lord, once the entire package is paid, the employee receives it, then thereafter the relationship ceases to exist. But since that payment was made as early as in 2014, the last installment, my lord, our case before my lords would be that the unilateral decision of the government fixing to 31st July 2011 as a cutoff date has been rendered meaningless on their failure to pay. Now, secondly, since the last installment was paid in 2014, my lord, our contention is that we are at least entitled to payment till 2014.
Okay.
No, no, but here, since the parties are not there, my lord can fix a date.
We'll do it after 2 weeks then.
My lord.
On the absence of the
My lord, let it come up any time after Easter's, my lord.
the absence of the learned counsel for the respondent 5 and 6 to be present in court, in court, the learned counsel for the petitioner, as well as the learned GA appearing for the respondents 1 to 4 respectively, has submitted that this matter may be adjourned for the day and to be posted to another 2 weeks. Accordingly, this is matter to 2 weeks.
Obliged, Your
It will
Lordship.
come up, maybe on 23rd, 24th, 25th, or any day after that.
Obliged, Your Lordship.
Item number 5.
This is a continuation of the hearing. The last occasion,
You have been heard?
I finished my part.
my colleague has finished his submission.
Respondent has to start.
Shillong Lab Mehta, second appeal.
So you will start.
Well, now
But
before,
I don't think you'll be able to complete it today.
well, it may not be able to complete. But still, any lordship allow me.
Because we have the reference at 11:30.
11:30.
Oh, 11:30. In that case, may I suggest tomorrow, subject to lordship convenience? Since the lordship, my colleague has already advanced, it doesn't require for posting for a long time.
Not tomorrow. Tomorrow we have another DV. Then in the second half, I'll have to sit with His Lordship, Chief Justice.
Any days, Thursday, Friday, subject to lordship convenience.
Can have it on Friday. Friday one case now. Huh? Rightly. We'll have it on Friday, Mr. Friday. On pre-made by parties. This is matter on Friday.
Item number 6.
Lordship, this matter I am for the private respondent. Well, Lord, I'm not ready with the matter today. My Lord, kindly accommodates me only for today. My Lord. Any other date, my Lord.
It's a review.
My Lord. Any other date.
Review is not with, you see, the review is between the petitioner and the court.
My Lord.
That's true.
I understand.
That's true.
My Lord, if kindly accommodates me only for today.
You're nitpicking with the court. Nothing else.
Only for today, my Lord.
If it is a fact, we'll graciously accept it. That's the law. So what do we do?
Not any other day convenient to this honorable court.
Like I pointed out last time, I finished my part last year, July. I'll obviously have to refresh honorable court's mind.
So let my friend refresh this honorable court, my Lord.
We can't do it piecemeal all the time. If he's not ready, he's not ready.
Any other date convenient to this honorable court, my Lord.
Last time his file was missing, today he's not ready.
My Lord, I have other reasons actually.
You're appearing for private.
My Lord.
Or the
I was the petitioner, my Lord.
appointee.
I was the petitioner.
You've been appointed. No, you were the petitioner.
Yes, ma'am.
Okay. And
She was
Mr.
the-
General, you were referring to the process,
I was
the
the
advertisement and the selection process thereafter.
my lord. I couldn't get it.
You were referring to an advertisement,
Yes, my lord.
and for which the selection process has,
Has been conducted,
Has been conducted.
and that process, my lord, the selection through that process is under challenge in another petition.
That's a different issue.
That's a different issue. My lord. That's a different issue.
No, but it would have, as far as
Yes.
third-party rights are concerned,
Yes.
it may have a bearing.
It's already arisen.
Not really, for the reason that if I succeed in convincing this honorable court that there is some modification that is required in the judgment passed by this honorable court, then what would happen is the selection process conducted thereafter, because the advertisement that was issued was on the strength of Lordship's order. Now, if I succeed, if Lordship's order goes, then the subsequent events, the advertisement, etc., automatically goes. Automatically goes.
If at some point of time, if the selection process has been halted,
yes, my lord,
then.
My lord, so far there is no stay. The new candidate is already joined.
Oh, really?
Yes.
Then
it's already in service.
Because the advertisement was issued during the it was issued during the pendency of the review petition. So any action taken
that is incorrect, my lord.
Let me finish. So any action taken on the basis of Lordship's judgment during the pendency of a review petition is subject to the outcome of the review petition. They've taken on the risks willingly by conducting a process when the matter was still sub judice.
Was this fact made known to His Lordship in the other court?
I'm not appearing in
my
that
lord,
matter.
IMS.
I'm not appearing in that matter.
The correct position is, my lord, the judgment of the advertisement was, my lord, 23/8. Judgment of this honorable court was, my lord, on 26/23. Advertisement was on 23/8/23. Review petition was filed in the month of November, my lord. So what my friend is telling is absolutely incorrect.
So if my friend appears to be ready, we can finish it today, my lord.
So my lord, that because yesterday I had some personal difficulties, my lord, it can be taken up any other day.
Pre-made by the parties, place this matter after 1 week.
My lord.
Lordship, if I may allow your Lordship, I beg to mention one matter for motion tomorrow. I'm so sorry, Lordship, for delay. By mistake, I make a mention in Sir's Justice Thank You Court, your Lordship.
Can it come up in due course?
No, your Lordship, the urgency is that the matter tomorrow, the execution petition before the lower court is listed tomorrow, your Lordship. So we apprehend
why would
that.
it come before this court?
Your Lordship, we are aggrieved by the order passed by lower court, the execution petition, which has granted post-award interest and the pre-award interest.
That would be you would have filed a revision petition.
Yes, Lordship, we are filing a revision
Then
petition,
why would
Lordship.
this court has got, this is not the roster.
Your Lordship, I'm so sorry, Your Lordship. I was informed that this court.
Lordship.